So our second topic is the alternative dispute resolution. Republic Act number 9285, or otherwise known as Alternative Dispute Resolution Act of 2004. In this particular law, dispute means a specific disagreement concerning a matter of fact, law, or policy in which a claim or ascertain of one party is met with refusal, counterclaim, or denial by the other. The term resolution denotes the way of finding solution of a dispute by the agreement of both the parties with some mutually agreed terms. In other words, alternative dispute resolution system means any process or procedure used to resolve a dispute or controversy other than by adjudication of a presiding judge of a court or an officer of a government agency in which a neutral third party participates to assist in the resolution of issues, which includes arbitration, mediation, conciliation, early neutral evaluation, mini trial, or any combination thereof. The Republic Act 9285, or Alternative Dispute Resolution, was created to actively promote party autonomy in the resolution of disputes or the freedom of the parties to make their own arrangements to resolve their disputes. Aside from the alternative dispute resolution system, the court may also conduct judicial dispute resolution. So we have the process of judicial dispute resolution. Before trial, the judge may refer the case to the mediation center for conciliation, mediation, or arbitration. If there is no settlement in the mediation center, the judge will conduct a judicial dispute resolution. If the judicial dispute resolution again fails, the judge may conduct trial to determine the guilt of the accused and impose the proper penalty in the case of conviction. Policy of the state regarding alternative dispute resolution. The state shall encourage and actively promote the use of alternative dispute resolution as an important means to achieve speedy and impartial justice and declog court dockets. We also have the forms of dispute resolution. One, we have arbitration. Arbitration is the private judicial determination of a dispute by an independent party. The disputing parties hand over their power to decide the dispute to the arbitrators. Arbitration is an alternative to court action or litigation and generally just as final and binding, unlike mediation, negotiation, and conciliation, which are not or non-binding. Take note that in arbitration, a neutral third party, or this what we call arbitrator, renders a decision after a hearing. Both the parties have an opportunity to be heard. It is the means by which parties to a dispute get the same settled without having recourse to court of law, or it is done outside the court. An arbitrator is basically a private judge appointed with consent of both parties. Another form of alternative dispute resolution is negotiation. It is a process whereby both parties communicate to reach a mutually accepted or acceptable agreement. Take note that in negotiation, participation is voluntary and there is no third party who facilitates the resolution process or imposes a resolution. In other words, people solve their own conflicts. And take note also that negotiation is not binding. We also have mediation. Mediation means a voluntary process in which a mediator selected by the disputing parties facilitates communication and negotiation and assists the parties in reaching a voluntary agreement regarding a dispute. Mediation is a decision-making process in which the parties are assisted by an outside intervener or the mediator, who attempts to assist the parties in their process of decision-making and reach outcome to which each of them can assent, without the mediator having a binding decision-making capability. Take note that in mediation, there is a third party or a mediator who facilitates the resolution process and may even suggest a resolution typically known as mediator's proposal, but does not impose a resolution on parties. Another form of alternative dispute resolution is conciliation. It can be similar to mediation, although conciliators' rule may be more directive and advisory. A neutral person called conciliator helps the parties try to reach a mutually acceptable resolution of the dispute. The conciliator does not need to decide the case, but helps the parties communicate and advise them so they can try to settle the dispute themselves. Conciliation is a cooperative method of dispute resolution. It is similar to mediation in that the parties to the dispute negotiate with the help of a trained conciliator. However, in conciliation, the conciliator exercises greater influence over the outcome than a mediator. The conciliator suggests options and possible solutions and usually has specialist knowledge. Decisions reached in conciliation are not binding, although decisions reached this way are normally followed. In short, dispute resolution is done outside the court. The parties themselves will decide the solution with the help of the third neutral party, particularly the conciliator. When the process of conciliation successfully done and both the parties arrive on the common solution, then conciliator formulate the terms and conditions of the possible settlement and share that with both parties. And after final discussion and approval of both parties, the settlement agreement is finally drafted and ensures that both the parties fully understood the terms of the settlement. So let's have the summary of the methods or forms of resolving disputes. Negotiation is the give and take process of people engage in when coming to terms with each other. In short, the parties involved will settle the dispute themselves. Mediation, the parties themselves agree to reach a mutually beneficial resolution with the assistance of a third party, or this what we call mediator. Conciliation, as mentioned above, a neutral third party plays an active role in suggesting a solution. Arbitration, the resolution of a dispute by a neutral third party. So the parties agree to let a third party make a binding decision. Litigation, the parties go to court or tribunal body to hear and try a certain dispute. All of the uh, methods, except for litigation, are commonly referred to as alternative dispute resolution. Mini trial. means a structured dispute resolution method in which the merits of the case are argued before a panel comprising senior decision makers with or without the presence of a neutral third person, after which the parties seek a negotiated settlement. It is conducted under an agreement of the parties. Each party and counsel for the party present the position of the party, either before selected representatives for each party or before an impartial third party to define the issues and develop a basis for a realistic settlement or negotiation. Early neutral evaluation means an alternative dispute resolution process wherein parties and their lawyers are brought together early in a pretrial phase to present summaries of their cases and receive a non-binding assessment by an experienced neutral person with expertise in the subject in the substance of a certain dispute. Alternative dispute resolution provider are institutions or persons accredited as mediator, conciliator, arbitrator, neutral evaluator, or any person exercising similar functions in any alternative dispute resolution system. Cases wherein Republic Act number 9285 does not apply. Labor disputes covered by Presidential Decree number 442, or otherwise known as the Labor Code of the Philippines as amended, and its implementing rules and regulations. The civil status of persons, validity of a marriage. Next, we have any ground for legal separation, the jurisdiction of courts, future legitimum or heirs, criminal liability, those which by law cannot be compromised, and those disputes referred to court annex mediation. The very purpose of court annex mediation is to encourage the parties to amicably settle their disputes or reach a compromise agreement to avoid protracted and costly litigation, just like the judicial dispute uh, resolution that I made mention in the previous slides.